afternoon, everybody. Thank you all for joining Kelley Drye today for what I hope will be an engaging discussion about how DOJ is reshaping its approach to corporate enforcement and what this means for corporations and for individuals. My name is Sandy Musumeci, and I'm a partner in Kelley Drye's New York office, handling white-collar investigations and compliance matters as well as commercial litigation. I'm happy to be here with you all. We are extremely fortunate to have among our partnership at Kelley Drye two very accomplished lawyers who were, until recently, federal prosecutors with the U.S. Department of Justice. They are going to share with us today their insights on how DOJ's recently announced new policies and enforcement priorities are being put into action, and perhaps more relevant to all of you here, what those recent policy changes and shifting priorities may mean for companies with respect to voluntary self-disclosure, cooperation credit, whistleblower complaints, and the exercise of prosecutorial discretion. Let me start by introducing my two new law partners, Sean Farrell and Tom Rybarczyk. First, let me tell you a little bit about each of them. Sean Farrell is a partner in Kelley Drye's New York office who specializes in white-collar investigations and compliance matters, as well as antitrust litigation. Prior to joining Kelley Drye, Sean served as chief of the Antitrust Division's New York office. And before that, Sean was an assistant United States attorney in the U.S. Attorney's Office for the District of New Jersey, where he served as chief of the cybercrime unit and the acting chief of the economic crimes unit. Sean began his career as a law clerk to the Honorable Arthur D. Spat in the Eastern District of New York. And Sean is an alum of Binghamton University and Fordham Law School. My second new partner with us today is Tom Rybarczyk, who is a partner in Kelley Drye's Los Angeles office. And Tom specializes in white-collar investigations and compliance matters, as well as commercial litigation. He, too, was previously a senior federal prosecutor, having served in the Central District of California as that office's chief of the Public Corruption and Civil Rights Section. Tom was a law clerk to the Honorable Michael S. Kelley of the United States Court of Appeals for the Seventh Circuit. And before that, Tom had a separate career as a newspaper journalist for a major metropolitan daily, where he covered public corruption, organized crime, and law enforcement. Tom is a graduate of the University of Illinois and the University of Wisconsin Law School. So let's get started with our discussion. Why don't we start with the big picture? Tom and Sean, what has changed most in DOJ corporate enforcement over the past few years?
Thanks, Sandy, and good to be with everyone here today. So I think if I had to choose two big changes, the first involves the antitrust space. And so back in July of 25, the Antitrust Division partnered with the United States Postal Service to create a whistleblower rewards program, which is the first of its kind in the antitrust space. Certainly have them in the securities space. And to some degree, the rewards program is modeled after the SEC program. But essentially, it's designed to incentivize individuals to come forward to the division and report criminal antitrust violations. It's probably the most significant policy change, at least on the criminal side, in decades. And I think it promises to reshape the way companies and individuals and lawyers who represent individuals think about antitrust enforcement and how they navigate antitrust enforcement. And we'll go into more detail about how it works and what the implications are a bit later. The second change I want to highlight involves FCPA enforcement. So in February of 25, the president issued an executive order announcing a 4-month pause in FCPA enforcement. And that was designed to give DOJ leadership an opportunity to assess all of the existing FCPA cases and investigations that were in the pipeline at the time, and to give them an opportunity to think through new guidelines on how DOJ should approach FCPA enforcement. So in June of 25, the DOJ put out that long-awaited guidance. And surprisingly, I think to some, I won't say FCPA enforcement is alive and well, but it is alive. The DOJ is now just taking a different view of the types of FCPA cases it's going to prioritize. So what are they thinking about? So the first is they're going to use the FCPA to primarily target international cartels. They want to focus on cases where the conduct undermines key U.S. business interests. They want to focus on cases that involve very substantial, high dollar amount of bribes, as opposed to some of the more de minimis payments that we've seen over the years. They want to focus on individuals. They are going to prioritize consideration of collateral consequences for companies in deciding how to deal with companies that are involved in these investigations. They're going to try and move these cases as expeditiously as possible to give companies certainty. And now a procedural change that is actually pretty important. FCPA unit no longer has the ability on its own to open investigations. To open an investigation, you now require the approval of the AAG for the criminal division. So those are the two major changes that I see that I wanted to highlight.
Thank you, Sean, and it's good to be with you all today. I also have a couple other areas that we want to talk about today, and we're going to touch on a little later. One of the bigger changes we've seen with the department is a more friendly corporate self-disclosure policy. Now, the department signaled last year that it would produce a more transparent corporate enforcement disclosure policy, and in March of this year, in many ways, it delivered. We will discuss later, while it is more transparent, there are still several considerations to evaluate before making the decision to self-disclose. The other big change that we've sort of seen in the last year is just a step up in increased tariff and sanctions evasions prosecutions, as well as investigations and civil enforcement, which should probably come as no surprise to folks given the administration's focus on tariffs since January of 2025.
And why should in-house counsel and compliance teams be paying particular attention right now?
At least on the corporate disclosure side, I think, Sandy, the biggest change is this March corporate disclosure policy. It does offer real, tangible benefits to companies in a more concrete way than previous iterations have.
Okay, so why don't we talk a little bit about DOJ priorities? Before I get into that, let me just note, I know everybody is here for CLE credit as well as to hear about DOJ's new policies and priorities. We will be giving a code toward the end of the program that you can put onto your affirmation form for CLE credit, so stay tuned for that. So back to the topic at hand. Let's talk a little bit about DOJ's current focus. Sean, can you tell us a little bit about what the Antitrust Division is prioritizing right now?
Sure. So if I had to sum it up in a phrase, pocketbook issues. So any industry that affects the price of household staples, primarily healthcare, agriculture, housing, energy, and any industry where your product or service is an input for any of those sectors of the economy. So far-reaching. And then, of course, the division continues, particularly in the criminal enforcement space, to focus on protecting the public fisc from different types of hardcore collusion that can affect taxpayer-funded programs. The one point I want to make about this piece is I think there's a tendency in the merger context for firms to think that if their proposed merger doesn't meet HSR thresholds, that they can feel safe. They can get lulled into a false sense of complacency. And I'm here to say that, even though FTC resources, even though DOJ resources are somewhat depleted, if you're in one of these industries, even if your transaction doesn't meet those HSR thresholds, you still have to be very careful because both FTC and DOJ are following all of these mergers. They have merger teams set up internally to evaluate transactions. And just because you're not meeting the HSR threshold doesn't mean that you're not going to get a CID. Doesn't mean that you're not going to draw the ire or at least the attention of FTC and DOJ, particularly if you're a firm that's trying to merge in one of these hot areas.
Tom, outside of the antitrust context, what can we expect from other DOJ components?
Thank you, Sandy. As I mentioned earlier, one of the big areas that there's been stepped up enforcement is in tariff and trade enforcement. Last year, the fraud section announced the creation of the Trade Fraud Task Force, which is a joint undertaking by DOJ, Department of Homeland Security, and within Department of Homeland Security, Customs and Border Patrol. The focus there has not really just been on criminal penalties, but also on using the False Claims Act, which has become a very powerful tool that this department has wanted to use. And that's also evidenced just by the multiple FCA settlements that came out last year related to customs enforcement. So companies and involved in trade policy, particularly those importing from China, may have exposure in this area. As far as sanctions, while the 2025 year and the new administration started a little slow, it appeared the pace of enforcement picked up with heightened emphasis on advisors and intermediaries, including investment advisors and real estate managers. The other big area that we've seen a focus is kind of what Sean just mentioned about the public fisc is procurement fraud is exemplified in the new division, which I'm sure most folks have heard about, the National Fraud Enforcement Division. In that, there's sort of two big areas. The first is just healthcare fraud, and the second is fraud involving government programs. With respect to healthcare fraud, they've been sending signals throughout, not least of which has been the West Coast Healthcare Fraud Strike Force. There's also this healthcare fraud data fusion center that was created last year, sort of to use artificial intelligence and to leverage HHS OIG data to find trends that they can either prosecute criminally or go after through an FCA type context. The other big piece of the procurement fraud is the benefits fraud. While many companies here may not be a target, any company that touches or handles government dollars, including state or local dollars, just may see stepped up enforcement here, including subpoenas coming their way to gather information. Earlier this year, the Civil Division announced that they're going to accelerate review of False Claims Act whistleblower complaints alleging fraud against federally funded state administrated benefits programs. So that's one big area where we'll see some uptick. One example of that is the Homelessness Fraud and Corruption Task Force here in Los Angeles. They're also, and that's been actually criminal prosecutions that have occurred with respect to that task force. But it also could affect those who have military and defense contracts as they just look for any sort of fraud that touches upon government dollars.
Thank you. That's helpful. Turning back to the antitrust context, Sean, how does the new whistleblower rewards program change the risk calculus for companies? What should they keep in mind?
Yeah. So before we get into the nuances of the program and what I think it means for companies, let's just level set and talk about how the program works, but also its intersection with the division's corporate leniency program, because I think it's important to understand both. So let's start with the leniency program. So under the division's leniency policy, a company can avoid criminal prosecution for antitrust violations, so Title 15 violations, by confessing their role in the conduct, fully cooperating with the division, and meeting certain other specified conditions. And for years, since 1993, the leniency policy has offered really substantial carrots. So the company avoids a criminal conviction and a fine. Companies that receive leniency can obtain non-pros coverage for their employees and officers and directors who cooperate. And in some cases, just as importantly, they're also spared treble damages and joint and several liability in the inevitable follow-on civil litigation. So it's, as I said, it's been a really, really important source of case leads for years. But I think the division has acknowledged that over the last 10 years or so, the policy just hasn't generated the same large international cartel matters that we were expecting to see, auto parts, ocean shipping, et cetera. So I think the whistleblower program is designed in part to really kickstart criminal antitrust leads. So how does it do that? So basically, the Postal Service has statutory authority to use money that's obtained from criminal penalties to reward whistleblowers who report on violations of law affecting the Postal Service. So in addition to showing that the conduct affected the Postal Service, to be eligible, you have to meet certain basic criteria. So one, you have to be reporting this information to the division voluntarily. When you come in, you have to be truthful, has to be complete. The information can't already be known to the government. It can't be derived from public sources. So you can't just, a whistleblower can't just wake up one day and read the Wall Street Journal and run into the division with those allegations. There has to be more to it than that. The one nuance I want to emphasize, because it's not yet clear from the division's guidance, but I think it follows logically from the policy. If the division has, let's say, a grand jury investigation open into, hypothetically, let's say, a price fixing conspiracy among widget manufacturers, but a whistleblower comes in and gives them some new piece of information about conduct they were already aware of. So let's say that whistleblower is on hot emails or hot text messages. If he or she comes in with those hot emails and text messages, well, notwithstanding the fact that the division already was looking at the conduct, I suspect you're going to see the division view that as original information within the meaning of the policy. So I expect the division to take a broad view of that requirement. One of the important requirements, the whistleblower can't have orchestrated the conspiracy or coerce others to join. And finally, in order to get paid out, the information has to lead to a criminal fine or a penalty of at least $1 million. So how does it work in terms of the amount that the whistleblower gets? Well, there's a presumption in favor of an award between 15 to 30% of the recovered fine or penalty, and that is solely within the discretion. Though I will say that the one whistleblower payment that has been made in January 26, and we'll get to that in a second, the division did give the whistleblower the top end of that range. So let's talk about the E-block resolution, because I think it's important, one, in terms of the lessons that we can draw from it, but it's important because it's proof of concept for the division, right? It shows that, less than a year into this program, they're paying out $1 million payment to a whistleblower. So it's something that people have taken notice of. So in January of 26, the division announced that it was paying a whistleblower $1 million. And that's because that information led to a deferred prosecution agreement and a $3.28 million fine with a company called E-block. And if you look at the DPA, basically E-block acquired the assets of another company. It's described in the DPA as Company A. This was in November of 20. And those assets included a digital platform that's used for auctioning off used cars. Now, at the time of the acquisition, Company A had been engaged for years in a conspiracy with Company B to manipulate those online vehicle auctions. So that's the underlying conduct. The interesting thing to me, in addition to the amount of the payment, is with E-block, the whistleblower reported that conduct internally before going to DOJ. And for reasons that are not publicly available, E-block made the decision not to act on that information. In other words, not to go to the DOJ and seek leniency or seek protection under the safe harbor for M&A due diligence. So it's a real missed opportunity for E-block. They could have gone and sought leniency. They could have, if they uncovered this conspiracy between Company A and Company B during the course of their due diligence, they could have, as I said, sought a declination under the safe harbor. For reasons not clear, they chose not to. And so a couple of things to tease out from this payment. It obviously increases the prospect that the division is going to detect cartels, because you now have individuals with first-hand knowledge who have a pretty powerful financial incentive to report. So now, in addition to gauging whether your co-conspirator is going to run to the division first, this program creates the risk that one of your own employees is going to beat the company to the punch and then effectively foreclose your ability to obtain leniency from the division. So I think it not only changes the risk calculus, but it also changes the speed at which companies have to make these decisions. And of course, in order to make the decision quickly, you have to have the sort of compliance program that detects these problems in the first place. So,
I mean, that's a very good point, right? You need to know sort of what the risk is of who within your ranks might be the whistleblower. How should a company adapt its internal reporting and compliance systems to be aware of these things?
Yeah, I mean, it just underscores now more than ever that you need robust, antitrust specific compliance programs that are going to enable you to quickly identify and analyze anti-competitive conduct. And you also have to revise your training and your compliance to make it clear to employees that there is a confidential channel in place where they can raise these concerns internally. So they need to know what that channel is, where the information is going, how much information they need to have in order to be able to come forward. And I would say it ought to be de minimis. They need to know that the company is not going to retaliate against them. It's not going to affect their careers within the company if they come forward. This is something I think the company ought to encourage. They ought to make it clear to employees that this is a good thing, that you're coming forward and that you're reporting it internally. It's also against the law since early 2024 to retaliate against someone based on an antitrust complaint. So those are just some of the changes I think that companies need to make to their training and compliance programs in order to address that now the whistleblower program is out there. And it might beg the question from some people internally, well, hang on, you're telling me I need to revise my training and compliance to educate employees on information that they could then use to beat us to the punch. I know that might at first blush sound amiss, but I think the reality is the program is out there. And the division is doing a pretty good job, particularly post e-block, of announcing it, getting the information out there. So this is something that companies have to deal with at any rate. This is coming. And so you have to be prepared. And I think letting employees know this is how you bring a report internally. This is what we're going to do with it. We're going to take it seriously. It's going to be investigated. We will try and keep you in the loop to the degree that we can. And you're certainly not going to be retaliated. If anything, this is going to be a plus factor for you in your career. I think if you do all those things, you actually reduce the risk that a whistleblower is going to try and go around the company and head straight to DOJ.
But then, of course, the company needs to actually do those things and follow up on the internal complaint that comes in. Right?
If they don't, then what's the point? If they're not going to go in and either one, take remedial action, or two, go to the regulators, go to the prosecutor, then yeah, that's right.
So how about a little bit more broadly, looking at DOJ outside of the incentives for the antitrust context? Tom, when you were a prosecutor, what made for a strong self-disclosure? And does that still make for a strong self-disclosure today under the current policies?
I think that it still does. And so I think some of the big factors in terms of what made for a good self-disclosure is when someone came in and was providing a disclosure to the government, if you're going to make that decision to self-disclose, then disclose. Don't just go halfway with the disclosure. One of the things that I would always frustrate investigators and frankly would lose credibility with the investigators is when you came in and you gave half the information that you may have had, or you didn't qualify it in some way. One thing is people will come in and just not touch on something instead of saying, hey, we haven't fully evaluated this fact yet. We're not sure how this plays here, but this is we're looking into it further. Instead of just completely omitting it. Like one thing Sean mentioned is that, in a hypothetical situation, if there's a grand jury investigation already open, the government may already know that fact. And by you coming in and not disclosing it when you know it, it just doesn't bode well, and it just doesn't get the footing right with the investigators if you're truly trying to take advantage of a self-disclosure. One other thing is at an early stage, if you've figured out who the folks are that you think are the most responsible individuals, be confident to tell the government about it. And you can always qualify it again, saying we're still investigating, but we believe it's these three individuals. Here's why we think that. Here's the evidence for it. Be helpful to the government. Unfortunately, I know they're on the other side in this context, but if you truly do want to get the full CEP credit, you truly want to try to negotiate the best resolution for your company. Again, it doesn't behoove you to try to take an obstinate stance on it or to try to take a stance where you're just going halfway on things. And then in the last piece of this, and I think kind of goes just to showing what Sean was saying about compliance programs, it's just being diligent in the investigation, right? It's sort of showing what you've done to investigate, what stones you've uncovered, what beds you've looked under, but also like if you haven't looked under them, why or what's the reason for it? Sometimes it might be a cost issue, right? It might be you can't turn over every rock or stone while you're doing an investigation, or there's just timing issues, particularly now, as we'll talk about with the CEP and the sort of the 120-day window you have to disclose after learning of a credible allegation.
So let's talk a little bit about that timing. Is there such a thing as disclosing too early? If a company learns about something and hasn't yet done its full investigation, what are sort of the factors there? And do you still want to make that early disclosure because the risk of waiting is just too great?
Those are great considerations, Sandy, and that's something that I do think it is something you need to consider on both ends. There are risks in disclosing too early, just as the risk of waiting too long. And again, I think it's a fact dependent evaluation of your case. So for the risks of disclosing too early, the biggest one is you're just inviting DOJ and the government regulators into your business before you have an actual real problem. It would obviously incur significant cost to your company without, at the outset deciding whether you need to actually do that to begin with in the first place. So that is a big risk that companies need to consider. Disclosure may trigger other disclosures on the SEC side, or which may lead to potential lawsuits, right? If you make a disclosure in your SEC filing, there might be securities fraud lawsuits coming down the pike that could have been avoided if potentially there wasn't actually something to disclose. The other big piece of this is rushing to disclose without sort of figuring out the privilege implications of it and how they're going to play, particularly in a parallel investigation setting, which I know we're going to touch on a little bit later. And the last place is, and I think we're going to hit on this as well, is disclosing before you have put mechanisms in place to make sure that the data that might be there has been preserved. You need to make sure right from the outset that you're preserving all the data that may be relevant to your investigation. As for the risks of disclosing too late, the new CEP kind of makes it pretty transparent for companies what those risks are. And it is just a more bright line rule than we've ever had in the corporate disclosure context. One is you lose the voluntary self-disclosure credit. The CEP gives you 120 days. Frankly, the new language they've adopted, it's a little bit more malleable than people think it is, because it says it may be even less if DOJ's use the phrase as soon as reasonably practicable. When you learn of this allegation, you need to go and disclose. And one thing I'll note about the disclosure, it doesn't mean you have to go to DOJ. The CEP says some state or federal regulator, you disclose a fact. So it doesn't necessarily, that 120 days, you don't have to run to the Department of Justice and make the disclosure. Maybe it's the EPA, maybe it's a state AG that you need to make the disclosure to. As long as you make it within that 120 days, that would at least preserve that window of that one prong of the voluntary compliance. The other sort of big areas of the risk of disclosing too late is the department not only has that 120 days, but they even have language now that suggests that you should disclose even if you haven't yet completed the internal investigation. That, again, is just a reinforcement about the speed at which they want disclosure. Obviously, if you wait too long, the obstruction concealment risk grows, as does individual culpability. The longer and longer you wait to make these disclosures, the better chance that someone's going to delete documents, hide things, including those culpable actors. And while those people may themselves face criminal liability later, it also is going to come back on the company that they didn't preserve that stuff, that they didn't, go in and make sure that didn't happen. Aside from the antitrust whistleblower program that Sean just covered, the DOJ has left in place its prior corporate whistleblower program. This does not include the SEC and CFTC whistleblower programs. The greatest risks in a lot of these cases, and what I've seen in my personal experience, and I'm not sure if Sean shares this, but is the disgruntled employee, the employee that gets passed up on a promotion, the employee that, just is not getting along with his or her boss. They are sometimes the biggest risk to these whistleblower situations. They may report internally, and if you do it correctly and you capture it, you can sort of handle it. But again, that they are a significant risk out there, and they could absolutely go outside the company and make that report, and then you're in a tough spot. So I think those are sort of the risks of waiting too long to disclose. Sandy.
Let me just ask a quick question. In terms of one of the things you're talking about is reporting, both of you were talking about, is reporting before the government has already started its own investigation or before there's public information out there about that. How is a company to know those things?
Yeah, that's a great question, Sandy. And unless, to Sean's point, unless you have a robust compliance program, which is sort of a defense against it and a bulwark, and unless they go public and they make there's a newspaper story or something else that comes out, the company's not going to know unless it gets a grand jury subpoena or other information that comes that way. So it is challenging, but that again focuses back to Sean's point. And I think the compliance program, not just antitrust, I think it needs to be broadly a good corporate compliance program when it comes to whistleblower information, just so that you can sort of rely on that if somebody goes outside the normal channels and reports something.
So from your perspective as a former prosecutor, what are some of the common mistakes that you have seen companies make that jeopardize receiving cooperation credit even under the prior policies?
So the biggest one is minimization. If you walk in there and you're spinning an email that is plainly showing a bribe, going over to an intermediary, and you're saying that bribe is not the bribe you're looking for, that's just the government investigators will just shake their head and you lose all credibility. That's just going to make them dig more and be more of a thorn in your side than, hey, we've got this bad fact. Here's what this is happening. We're dealing with this bad fact. Here's how we're dealing with it. And not if you don't own the bad fact, I don't know that you really want to go in there and make the presentation. You sort of have to evaluate where that's at. So minimization is a huge problem. I'm not saying contextualizing that bad fact is not something you should or shouldn't do, because you absolutely should, and sort of show why it's not material or other things. But to say that a bad fact isn't a bad fact is just not a good way to build credibility. One other big area is protecting certain actors. So if you're going in and you just, the CEO's got to get protected, right? For whatever reason, or the CFO or the senior director in this area, but really the evidence shows that is the bad actor, you've got an issue. You really got to square that up and sort of have an honest conversation with counsel about how to sort of proceed in that sort of environment. I've even been in investigations where obviously the in-house counsel have had their own lawyers. So it's gotten messy, and it's just one of those things where it's a real hard line to walk. But determining if there are bad actors and don't trying to hide like who's the bad actor and why you think they're the bad actor. And then the last big piece is explain your diligence, explain what you've done, explain how you've done it, and explain if you haven't taken a certain step, why. And listen, I don't think the government's going to say you have to spend gazillions of dollars to like uncover every fact. But you should at least explain why you didn't take a particular step in your investigation for cost reasons or for blocking laws that are in various countries. You couldn't get that information. There's various reasons for it, but at least explaining why helps, again, bring credibility. And that would be my biggest takeaway is credibility with the investigators.
And just to follow up on that, how would you square if you do go in early and part of the problem is you don't have robust compliance in the area where you found this misconduct, right? I mean, it's hard to sort of say, look, here's the compliance we have when you don't have it.
Absolutely. And so I think, again, owning it, right? I mean, saying like, hey, we didn't have it. We're putting it in place right now. We're working on it. Here are the things we're doing to do it. But we didn't have it at the time, and not trying to hide a bad fact. And so, yeah, I think in terms of on that front, that's something to talk about. The other part of this about going in too early is just the evidence of the evidence you have of the credibility of the allegation, right? So if it's just some random employee making an allegation that they don't seem to actually have concrete evidence of a fact or any sort of support for it, that's going to get viewed a lot differently even by the government than it is by, if you have to evaluate each sort of whistleblower complaint on its own facts, right? And so I'm not saying every whistleblower complaint has to be rushed to the door. You need to look and see in the credibility of it, and that should sort of inform the speed at which you address that issue.
So what would you say then are some of the factors? And I understand it's a fact-specific, specific analysis, but what are some of the general factors that a company with counsel should consider when misconduct comes across its radar, but the facts are still developing? So what are the factors for that go versus no-go disclosure decision?
So in addition to that credibility determination is of the allegation is also the gathering of the evidence to corroborate it, even independent of the claim. So let's say like they have some pretty specific facts that suggest that they know something. trying to like gather even just those skeleton facts from the outset to sort of figure out what those are, sort of will frame that. The other piece of it is just how big of an issue is it for the company? Is it a smaller issue that, may implicate only a couple, depending on what the issue is, $1 million or $2 million? That's obviously there's some consideration in that in terms of like how big the issue is for the government, at least for the federal government. Now, state AGs may have different perspectives about what's significant and what's insignificant, but that at least with the DOJ. And then the last piece of it is to your point, Sandy, is like where is the compliance program? If it is not a good one, what have we done to at least say we're shoring it up before we go in? Because you don't want to go in and just say, yeah, we had a terrible compliance program. We don't know what to do. Here's what we know now. Concrete steps about what the next steps are. It should influence your decision to go in early or not.
Can we, both of you, just talk a little bit about, so let's say a company does decide to make an early disclosure. It does it well, it is credible, it provides the information, and it's hoping to get, a non-pros or a deferred pros or a positive outcome. Are there still financial implications for the company of that disclosure decision? Could you address that a little bit?
Yeah, absolutely. So in the Title 18 context, right, yes, your main concern is exposure, is liability. What you're looking for ideally is a declination, failing that, an MPA or a DPA. But you also, as a company, have to be prepared in a case where there's a victim to pay restitution. If it's a victim case and you're seeking some negotiated resolution short of a charge, the department is almost always going to insist on restitution to victims. And that's true for disgorgement as well. If they're ill-gotten gains, like if it's a bribery case, for example, you're handling an FCPA issue for a company, and as a result of the bribes, your company was able to obtain millions of dollars in contracts it otherwise would not have obtained but for the bribe. You have to be prepared when you go in there, when you decide to cooperate, when you decide to self-disclose, perhaps to disgorge those ill-gotten gains. So that has to be part of the calculus in the Title 18 space. In the antitrust space, it works a little bit differently. Your concern, once you've requested leniency, as long as you keep making progress towards getting a leniency letter, you're not going to be concerned about a charge. Restitution, typically the division will take the view that private civil litigation is the better way to enforce those rights. But as a leniency recipient, you have statutory obligations to cooperate with civil plaintiffs to a certain degree to make them whole. You're not joint and severally liable. You're not eligible for treble damages, but you still typically have to make things right with the victims of your anti-competitive conduct. So absolutely, financial penalties, those considerations have to be part of the calculus when you decide to go forward.
And just to piggyback off Sean, I think there's also what we'll talk about in a second, the follow-on other penalties, right? It's not just the DOJ penalties that might come forth. It might be the civil follow-on lawsuits that you have, the securities fraud lawsuits, the other state AG lawsuits, the SEC itself, depending on what you're dealing with. So there's and none of those are actually subject to the, even the DOJ civil division is not subject to the CEP. So there is like a strong indication, I think, for the DOJ to sort of work those things out as a holistic approach. And there is even a parallel investigations memo that the department put out last year, sort of really encouraging the DOJ to take a holistic approach, including with foreign authorities. So let's say you've got an issue in Britain or an issue in France, and you're paying penalties there, you pay penalties in the US. The department has now been encouraged to sort of figure out what the whole amount is and credit sort of the amounts that are being paid in foreign jurisdictions, as well as obviously in US jurisdictions too, for the conduct that's at issue. So there is more, at least that's more positive than it previously had been. And so that's another consideration, though, is just the follow-on other agency investigations.
Yeah, along the lines in the competition space, this is really important because competition regulators over the last 10, 15 years have become so much more aggressive than they used to be following the DOJ model. They typically have a good relationship with DOJ, so they will try and coordinate is a difficult word, but they will try and ensure that they're not penalizing companies for the same conduct, but they're certainly much more active in this space. And many of them, modeled after the Leniency program, have their own immunity programs. So it's something to be mindful of when you decide to go into DOJ, whether you also want to go to another competition regulator who may have a similar incentive program.
So I want to talk a little bit more about this multi-agency issue. Before we get really into that, I see we got a question from the group listening, asking what does disclosure mean? How does a counsel choose who to contact, either within DOJ itself or DOJ versus another law enforcement agency or regulator? And before we get to that question, I should just say, if others have questions, please feel free to add them to the chat and we will do our best to get to them. But
So,
Tom and Sean, what do you think about that?
I mean, so at least from my perspective, it doesn't matter who you go to at DOJ as long as you go to somebody. If it's DOJ, you choose, and you don't have to go to DOJ under the CEP policy. You could go to the FTC. Let's say it's an antitrust case. You could go, as Sean said. I don't know if foreign regulators would contact. I need to look at that a little bit more. But in terms of at least domestic, a state AG, if it's an issue that it's a privacy issue, let's say, or there's some other issue in that sort of line. But you don't necessarily have to go to a specific DOJ person. People like Sean and myself or Sandy, we know folks at DOJ. So if you engage someone like ourselves or someone like at a big law firm that has DOJ contacts, they can always walk in a complaint too, or walk in a presentation and say, we've got something happening. We needed to talk to you about it as an option. So.
Yeah, in the antitrust space, if you uncover a per se or anything that's close to the line of a per se violation of the Sherman Act, you go directly to the Antitrust Division, and specifically you go either to the Director of Criminal Enforcement or you go to the Deputy Assistant Attorney General of Criminal Enforcement, and you request a leniency marker. And once you've made that decision, you do it as soon as you possibly can, because there's only one leniency recipient at a time. So it is not uncommon. There are people who have been around the division for decades who will tell you that sometimes a marker is given out to company A, and company B, another co-conspirator, has received, made a call 15 minutes later. It's sometimes that tight. And so time really is of the essence. In the FCPA context, you're going to reach out to the FCPA unit directly. And for other types of conduct, I think, as Tom says, it depends. The important thing is I would not get hung up on who you reported to in the first instance. Once you've committed to this, once you've made the decision to report it, you need to get it to someone quickly. If, for example, let's say, you think that it could be an investigation that would pique the interest of your local U.S. Attorney's office, call the don't worry about, taking hours to find who the chief of the criminal division is. Just make the call. They'll get you to the right person.
Let's talk about some issues where there are multiple agencies that would have an interest in particular conduct and let's say do. So sort of multi-agency or multi-jurisdictional investigations. Tom, could you speak a little bit about some of the challenges that internal and external counsel will face if they have a multi-agency investigation going on?
So one of the big issues you're going to run into with this is just getting a sense of everyone involved. And lots of times, if your company gets contacted with a subpoena, you're not going to know. So that's one big reason to sort of control the narrative in terms of going in and self-disclosing is you then, at least at the outset, know who you're disclosing to, and you can try to disclose to parallel groups, right? So you're not just disclosing to one or the other. And so you know who's involved and you can control the narrative. But if getting a sense of everyone who's involved is very important from the outset. I know from my personal experience, we used to have memorandums of understanding with the SEC, with our civil division, with other groups in terms of what information we're gathering and what we'll share. To Sean's point about the FCPA, in terms of disclosure, you obviously could disclose the fraud division. The SEC also has its own, obviously, books and records violations that you can always disclose to the SEC on as well. But you should expect if you've got an FCPA investigation, you likely have yourself an SEC investigation on a books and records violation that you're going to be dealing with at some point. One other big sort of issue, again, I think I mentioned this earlier, but is grappling with the different privilege waiver issues that might come up. And the last big thing, I think, is trying to sequence your investigation with respect to all these other follow-on lawsuits that often come in terms of like a civil complaint for securities fraud or other like types of fraud allegations that might come across the company. What you don't want, and we'll talk about later, is some Fifth Amendment asymmetry, which basically is like you've got people who feel like they still have corporate criminal exposure, personal criminal exposure, taking 5 during depositions. It's just not going to be good for the company. It's not going to be good for company liability. So sort of getting your arms around that and trying to control that narrative from the outset. It's not easy, but it can be done and can be done effectively.
So, Sean and Tom, could you speak a little bit to, are there any sort of tricks of the trade or things to keep in mind to avoid inconsistencies when you're dealing with DOJ and other regulators or other international authorities simultaneously?
I think the big thing to identify, Sandy, at the outset is who's involved. And if it's DOJ, they tend to have the strongest investigative tools, at least domestically, to get the documents and the things they need from the company and from third parties that other agencies may not have. It's particularly like state attorney generals are very limited, at least in California, for example. They don't really have grand jury authority to get bank records. They can't just go cut a grand jury subpoena to get bank records. It doesn't work that way in California. So there are lots of limitations with these other agencies that DOJ does not have. And if you think one sort of way to then deal with the inconsistencies is to find out who those multiple agencies are and get a handle on all the facts before you start really talking to all of them. And one other thing to do there is to sort of designate one counsel as like the person having all the communication. That sort of avoids like having this counsel talk to the FTC, this counsel talk to the SEC, and then you're getting inconsistent narratives just because it's a game of telephone, right? You've got different people providing different things and saying different things. And so documenting what's being said and being said consistently from one sort of like publicly facing counsel, or I guess investigation facing counsel, is another way to sort of avoid those inconsistencies. And then I think managing the public narrative, whatever that is, you're going to come with, if you've made a disclosure and it's been disclosed publicly, making sure that public narrative does not in any way sort of interfere with the investigated side narrative, because then those investigators are going to bring that up in any sort of interview, meeting that you have with them at sort of a different time.
Sean, is it different in the international context?
No. I think, look, to the degree when you have multi-agency investigations, to the degree that they are able to share information, you should assume that they are. Now, there are all sorts of limitations on that, particularly when you're talking about parallel criminal and civil cases. But as Tom said, all these agencies have MOUs, have parallel proceedings policies in place that guide what they can and can't share. But you should assume that they are sharing information. And so I think it's really crucial to make sure that you're managing the flow of information, that you're not getting siloed, like where you have some DOJ team here and the Competition and Markets Authority team here, and they're not quite sure what each is presenting to the respective regulator. So you just have to make sure that you're being consistent. You have to make sure that you understand also what their limitations are in terms of what they can share. Often I think they're open to giving you that information. So at the outset, if you know that there's another regulator involved, that there's another enforcer involved, make sure you understand whether they're communicating and what exactly they are able to communicate.
And so when you have parallel proceedings, whether domestically or internationally as well, where do companies generally run into trouble? What are sort of the risk points where you have a parallel proceeding?
So I think, as I mentioned earlier, Sandy, it's this Fifth Amendment asymmetry is the biggest one when you have parallel proceedings occurring, particularly civilly, and there's going to be depositions being taken of various key witnesses. You really want to get your arms around the criminal investigation first. And there are many mechanisms to do that, right? You can stay discovery, you can stay your civil case. And lots of judges will agree to that because it just doesn't make sense to like proceed forward if you haven't sort of figured out where people are going to fall within that ambit. The other big thing about it is, as Sean mentioned, is managing grand jury secrecy versus civil discovery demands you might be getting. You're going to get grand jury subpoenas. You have to worry about sort of what you're providing the government and what you can disclose and can't disclose in a civil discovery demand response about those sort of things that are happening. And the last big thing that I think that I've seen is what you're admitting to and agreeing to admit to in a non-pros agreement or a DPA. Those are things really you need to consider as to how that's going to affect the other investigations, because those obviously be facts deemed admitted against the company at a later date.
So just shifting gears for a moment, we've been talking about your company's compliance program as an important element of a self-disclosure. Let's talk a little bit about what that means. What does the Department of Justice currently view as an effective compliance program in practice? Not just sort of what you have on paper, but what you have in place.
So the division put out some guidance on what a state-of-the-art compliance program looks like in 24. And Tom can add to this, but I don't think it differs dramatically across different subject areas. I think in the antitrust context, you want a robust program that fits within a larger compliance program that is specifically tailored to your business lines, specifically tailored to your markets. So, a one-size-fits-all approach to compliance that doesn't take into account how the different business lines operate, different responsibilities of the employees who are being trained, I think the DOJ is going to find wanting. You need a culture of compliance from the top. So senior leadership, the board, senior execs, they have to be involved in fostering a very positive compliance culture. They should be involved to the degree possible, or at the very least, they should make it clear that training, compliance, these are not cost centers. These are not things to be avoided. This is an important part of the company's culture. You have to devote resources to it, and that will. I think DOJ appreciates that will differ. A large bank's resources are different than a startup's, and their compliance and training programs may reflect that. But you just want to make sure that you're looking at the size of your company, and you're ensuring that your training and your compliance programs are a fit. And then you need that risk assessment. You need to think about how your employees interact with their competitors. You have to look at your HR practices. You have to look at the types of communication platforms that your employees use. Are certain business lines, engaged in benchmarking? Are they using pricing algorithms? How are you using AI? And of course, this isn't etched in stone. This has to be an evolving process. So you really need to understand how your business lines work, and then tailor programs, tailor trainings accordingly. You have to communicate very clearly about this with employees. You have to let them know that they're going to have to sign up for trainings, that they're going to have to attest that they were trained. They're going to have to sign codes of conduct. And again, that's not some chore, not some box checking exercise, but an important part of their work at the company. And then you have to monitor it. You have to audit it. Sometimes that means monitoring communications on certain platforms. Sometimes it means providing periodic reports of how it's working, of the sort of complaints that you're getting, what you did to document them, what you did with those complaints, and so forth. And as I said before, you need to make sure that it is clear to your employees what the line of reporting is. If they uncover something, where do they go? What are you going to do with it? Who's going to have access to that information? What does that mean for them in their day-to-day? What does that mean for their future at the company? How long are you going to take to investigate that? What are you going to do with that information when it comes to the outside world? You need to make all of that clear to your employees. And you also have to remediate. I mean, Tom addressed this before, but when you uncover misconduct, you may have to discipline employees. You may have to do an assessment of which controls failed and why. You need to make changes to those controls. You may need to publish those changes that you've made company-wide to make sure that the employees and eventually perhaps regulators know that you've been responsive. So those are kind of, I think, the hallmarks. Tom, I don't know if you have anything to add.
No, I think that's exactly right. And I think it doesn't, I know Sean was speaking more in the antitrust realm, but I think it's just generally a robust compliance program, sort of hitting on those prongs that Sean touched upon is just important overall for any sort of effective compliance program.
So I see we're getting close to time. Just to wrap up a little bit, to each of you, if you could give in-house counsel one piece of advice if they're heading into a potential investigation, they've gotten wind of some problem in their company, what would that piece of advice be?
Yeah, this is not earth-shattering, but it is important, and it's preserve. I mean, and I say that because you can do everything right, and you can uncover the conduct, but if you don't preserve the underlying evidence, it's just the fastest way to get your company in hot water. And that's true with DOJ. It's true in private litigation. It's a bad look, when you get in front of a judge. If you're destroying information, whether that's intentionally or inadvertent, it's a problem. So you have to have your arms around how your employees are communicating. You have to make sure that there's a sensible retention policy in place. And like any other policy, once it's in place, you got to follow it. And if you don't, you risk adverse inference instructions litigation. You risk spoliation claims. Or in the worst case scenario, you risk obstruction of justice charges. And that is obviously the last place you want to be.
And from my perspective, it'd be speed. The new CEP policy prioritizes speed. And what that means is if an allegation is credible, as we discussed earlier, you need to address it as soon as you possibly can. And you need to decide the decision as to whether to disclose or not as soon as you possibly can. Those incentives now have been, I would say, incentivized in a way that they never have been before in terms of the speed at which you need to make this determination. Waiting under this new CEP does you no favors if you really have something that you need to disclose, and would actually just rob the company of many of the benefits it otherwise could receive.
We got a question on the chat about where the affirmation for the CLE credit is. I believe that it is going to be circulated again, a link to it on the Zoom chat, so everyone should be able to find it there. And seeing that we're running out of time, we have gotten some other questions about things like scope. How does one define the scope of a disclosure? How do you know if you're going broad enough? You don't want to go too broad because then you have DOJ looking at everything that you're doing. Those are all things that I think probably you both would agree with me are things that you really are fact specific and want to consider carefully with counsel, experienced counsel. I would like to thank everybody for joining us today and thank you both for sharing your insights and experiences. There's no doubt that the calculus of whether, when, and how to self-disclose internally discovered misconduct is really a challenging and sometimes maybe always very scary decision that a company might have to make. And clearly it's very highly fact specific. So, again, I think getting counsel who are experienced in this and who can delve into your specific situation is really important. We hope that this overview has been helpful for everybody. Thank you so much for joining us. We invite you to follow up with any of us if you have questions or concerns generally or more specific to your investigation. Specific to your organization. Thank you again and enjoy the rest of your day, everybody.